Hi, my name is Stuart Green. I'm the founding and managing attorney of Stuart Green Law, and we are an estates, trust, and tax planning law firm focused on high net worth estate planning. If you like this video, please go ahead and like it on YouTube, as well as subscribe to our channel. We are constantly putting out new content. So if you want to stay up to date on modern trust and tax planning concepts, this is a great way to do it. So recently I put out a video talking about 10 reasons why South Dakota has the premier trust planning statutes in the United States, as well as one of the best in the world. So that was an introductory video to those concepts, and today I want to drill down on one of the items that I talked about in that video, and that is privacy. So privacy is increasingly more important to clients, and there's a variety of different reasons for that. So one of the, I should say, elementary, more basic privacy planning strategies for all clients is using a revocable living trust for purposes of avoiding probate. So just kind of a quick reminder, with probate, when you pass away, any assets that you have in your individual name have to go through the probate process of the local court. The local judge oversees this process, and any information that you submit to the court, and they require you to submit information regarding the person who's passed away, their assets, family members, contact information, that kind of thing. It all becomes part of the public domain. Anyone can access that information. And kind of a funny story, I think it's kind of a funny story. At one time early in my career, had a client who called me and said that their father's business partner had passed away. The business partner had owed dad money for many, many years, but dad apparently was a very generous man and kind of just, swept it under the rug because he believed that the business partner didn't really have the money to pay. So the client called and said, "Hey, can we get our hands on this information?" I said, "Yeah, give me a few days." Before I could call the client back, the client calls me and says, "Hey, I got the information, and the dad's business partner who passed away actually had $30 million worth of assets in their individual name." And they found all of this out through the probate process, and the fact that that information is available to anyone. So first and foremost, regardless of jurisdiction, you should be using a revocable living trust to avoid probate, to keep your affairs private. Now let's go even a little deeper. So to the extent that a trust is subject to some type of suit, it isn't necessarily protected from public domain. So not all states have privacy laws regarding trust. Well, South Dakota does, and they take it very, very seriously. And this is very important for wealthy families and families that may be subject to greater legal risk or exposure, certain types of professionals, business owners, celebrities, that kind of thing. And so in South Dakota, there is a total, complete, forever seal on any information in a court proceeding related to a trust. No one will ever be able to access information regarding the provisions of the trust, the content of the trust, the assets of the trust, the beneficiaries, the settlor, the trustee, any of that information. Again, this is South Dakota trust statutes. Most states do not have any type of privacy laws in place. Delaware does. It is not a forever seal. I believe it only lasts 3 years. So there is a shelf life on that, which I don't particularly know why you would put a shelf life on it. But South Dakota doesn't. So again, it is a very, very superior privacy statute when it comes to that. One of the other really interesting things that South Dakota does, and no other state does this to my knowledge, is that they offer quiet trust. So what does that mean? In most states, when a beneficiary turns 18 years old, they have the right to the details of the trust that they benefit from. So that has to become available to them. In South Dakota, it is up to the settler, the person setting up the trust, how little of information is shared with the beneficiaries. And this is something that can be updated over time. So if at some point mom and dad set up a trust for the benefit of their kids and they decide they want to share no information at all because they're scared that son and daughter may rely too heavily on a trust that benefits them once mom and dad passes away, and they may not want them to develop that type of attitude. So mom and dad say, no information whatsoever. We're not even going to tell our kids. We're going to put a plan in place that if for some reason our kids do need money, we have a team there who can take care of the kids and make distributions on a as-need basis. Well, maybe mom and dad decide before they pass away that's not actually what they want to do. They can update it. Or maybe they put the team in place once they have passed away and give them the discretion to make a decision on, hey, you know what, the beneficiaries here should have a little more information. So there's a ton of flexibility. But bottom line, when it comes to privacy, South Dakota is by far the best jurisdiction for this. And as I might have mentioned, have certainly mentioned in other videos, the beauty of South Dakota trust planning is that you don't have to live in South Dakota to be able to take advantage of their strong statutes. You can be a resident anywhere in the U.S. as well as abroad. So it really pays to sit down and have conversation about which jurisdiction makes the most sense for you and your family when it comes to your trust and wealth planning.